In the United States, and specifically in Florida, we seem to have this notion that it is okay for one parent to withhold time sharing for the other and to make, by judiciary order, the parent that doesn't get to see their kids, even though they desperately want to and they volunteer to all of the time, for a judiciary fiat, by judiciary order, to make that parent pay additional child support, even though they are being denied any and all time sharing. That to me seems a little cruel. Now, I tell clients all of the time, and I mean it, and I am quite strict. Child support is for the benefit of the minor children, not for the benefit of the person receiving the money. Of course, many people still gripe, well, my ex-husband is spending it on boats. My ex-wife is going out to Arby's and dancing and drinking with all of my money. It is not your money. It is the children's money if child support is ordered to be paid. Is it possible that the person receiving that money acts irresponsibly? Of course it's possible. Still possible is that the person receiving the money uses it as petty cash and uses their own personal money to provide rental roof income, to provide housing income, to provide food, to provide book bags, to provide school lunches, to provide clothes, uniforms, shoes, diapers if the kids are young, to provide for all of the daily needs and necessities, including childcare, with your children. Now, if $500 a month is the amount of child support that you're ordered to pay, mind you, child support has not yet been increased for inflationary costs of living, nor has it been increased based upon the fact that everything costs twice as much, and the person that is mostly responsible for the kids is now shouldering an even heavier burden, which may preclude them from being able to spend as much time with the children. Forget all of that for a moment. If you pay $500 a month in child support, and the person receiving that spends it on recreational activities involving the kids, you might not approve of those activities, mainly because you're not involved with them and you wish if you had spent $500 that you had been at least invited or you had control of the purse. Of course, I understand that, and I sympathize greatly. But do we really want to spend billions, with a capital B, of dollars adding to the Florida Department of Revenue and the Florida Family Law Court to ensure that every dollar is accounted for, to ensure that there's some third-party customer service, whether in the United States or in another country, through call centers and call center analyses and automated reports and AI generated this and AI generated that? Do we really want to ensure that the person receiving $500, $200, $600 of child support has to submit all of their financial records? Do we really want that to happen? Do we really want the person to be forced to comply with that sort of a regulation? Does anybody believe it is in the best interest of their children for the person receiving child support to be placed under a microscope to ensure that every penny is objectively, and how would you even calculate that, objectively spent on the kids? Maybe, and consider this, the person receiving child support feels the money you pay them as the payor adds to their income and allows them to have a few extra needs and necessities or a few extra leisurely activities for the kids they otherwise would not have been able to afford, and they might have been rationing the money. Let's dispel one last myth with the time we have remaining in today's episode. And that myth continues to be that so many of you believe that if you have equal time sharing, and that is the reason you are fighting for it, which I sure hope not, but if that is the reason you are fighting for it and you believe that equal time sharing nullifies child support, then you know nothing. Nothing about Florida law, nothing about how child support is calculated, nothing about the legal system, and certainly nothing about the Department of Revenue or the Florida Family Court. If you have the same incomes, the same time sharing, and you each claim one child in the perfect magic unicorn scenario, and there is no health insurance expense because of Florida Kid Care or some other form of Florida government health insurance, then maybe there's no child support to be paid. Maybe the numbers work out to zero in a unicorn, magical, mythical, wonderful world of Oz. In the real world, even with equal time sharing, it is more common that one party spends $500 a month on insurance, or one party spends $900 or $1,200 on daycare. These things are common. In 50-50 time-sharing plans, though the presumption, are not always granted and not always settled upon. People's incomes are rarely identical. It is more common that one parent will owe child support to the other parent, and whether you like it or not, and whether you prefer that the parent receiving it spend that child support money on McDonald's versus Ruth's Chris versus Dairy Queen versus Dave & Buster's versus putt-putt golf versus gymnastics lessons or uniforms, frankly, that's none of your business, because the law says it's none of your business and there's nothing you can do about it.